Okay, guys, Chapter 4, Criminal Law and Defenses. So, it's another one. Okay, guys, Chapter 4, Criminal Law and Defenses. These chapters I know are a little bit on the long side. I try, but there's so much information crammed into 9 weeks, so I hope that you were prepared for this, but I'm doing my best to try and go as quickly as possible without skipping over a lot of really important stuff. So I'm going to of course I am skipping over the learning objectives. Is hazing a crime? I'm going to kind of skip over this, although I hope that we know that hazing is a crime. As if you've listened to or watched the videos that I posted, you'll probably know that I do have 2 kids away at college. So you can understand my interest in the whole concept of hazing. My daughter is actually in a sorority. Hazing is a crime. It is a significant issue at a lot of colleges, by the way. So anyways, is it a crime? Yeah, it is. What is law? Rule of law, guiding principle of the United States legal system, which states that no single person is more powerful than the law. Laws are formal rules of conduct sanctioned by the state. We talked about it earlier. If it's not written down somewhere, it's not a law. We also talked about in Chapter 1 that ultimately, why do we have laws? If we didn't have laws, we would probably all run around like maniacs, even more so than we already do. The first little bullet point here, rule of law. How true is this? I don't know. You all would probably have a decent argument if you were to say that, are there some people in our country that might seem above the law? I don't know. What is the purpose and function of the law? Why do we have laws? Again, we've sort of touched on this. We want to protect people and their property, make sure that there's some clear standards of behavior so people understand what they can and cannot do, limit the government's power. We need to do that, to punish people. Regulate and maintain social order. Again, if we all didn't know what we could and couldn't do, would we run wild? Possibly. And serve as a symbolic function, sending a message that society disapproves of particular acts. We talked about this again in Chapter 1 with mala in se and mala prohibita. So we would be talking more about mala prohibita laws when we're talking about sanctioning behaviors that the society in general disapproves of. There are, obviously there's a history behind the whole concept of a law. Back in the day before we had paper and things like that, how did people convey laws and rules? Well, before recorded history, there were some unwritten social norms. The Code of Hammurabi, I believe, was the first written set of laws. And basically, the concept was you suffered punishment that was equal to your offense. So, if you killed someone, you can guess what the punishment was. It would provide compensation for the victims. There's other different types of laws, principle of an eye for an eye, Mosaic law. But when we say eye for an eye, it's kind of like, I do to you what you did to me. You rape my mom, I rape yours. I know that sounds horrible, but I'm trying to catch your attention when I say that. Ancient Greeks and Romans relied heavily on written laws. And we now, in the United States, rely heavily on written laws. Common law is something that we kind of took on from England initially, but we don't use it anymore. Common law was something that was kind of an unwritten law. But it was kind of a concept that judges would interpret cases. Now, judges still do interpret cases, but case law here now sets precedent, meaning if a higher court changed a rule, if a higher court ruled in a different way than a lower court, then the higher court's ruling became the new law. So that is called a precedent, or previous court decisions that have binding authority on subsequent cases, is how your book describes that. Remains the foundation of the legal system in the United States. So although we don't actually use common law, because common law was specifically unwritten, we do use legal precedent as a way of enacting laws, which is kind of tricky. But anyways, United States Constitution is how we base most of our laws in the United States off the United States Constitution. So the Constitution kind of gave us a baseline throughout the United States on how we were going to write our laws, what kind of protections each of us has in the United States against the government. So yeah, the Constitution was basically the first document that the United States, specifically wrote to address laws in the United States. Statutes are laws that are enacted by the legislatures or Congress. And then ordinances are laws that are enacted by local governments, like cities and counties. So something like a curfew. The city of Fresno has a curfew of 10 p.m. That's a city ordinance. So you might go to a different city like Selma. I'm making this part up as for a time. And maybe Selma thinks that a curfew should be 9 o'clock. Again, I don't know if that's true or not. I'm just making that part up. But Selma, the city of Selma, if they want to, they can make the city, they can make, by way of city ordinance, they can make their curfew 9 o'clock. So that's just an example of a city ordinance. The Model Penal Code is a suggested penal code drafted by the American Law Institute. What is a penal code? A penal code is a set of laws in a ginormous book that basically lays out everything that is against the law. If you look at the California Penal Code, it is probably 3 to 4 inches thick, and absolutely everything that is against the law in the state of California is written in that book. So that is one book with a set of laws in it that we have to live by in the state of California. But in the state of California, we also have to live by case law, which are decisions that judges have made in court cases. So although the majority of laws that we have to abide by are in a penal code book, some of them are also in these other giant books that record previous court cases. Am I confusing you now? I don't know. I hope not. Oh, okay. There are different sources of law or types of law. Administrative law are bodies of law that concern, basically this is more of a regulatory law. International law obviously would consist of laws that deal with our relationships with other countries, or that other countries have with us, or that we have throughout the world. Other countries obviously have significantly different laws than we do in the United States. A lot of times we, as Americans, and probably myself included, will be frustrated by our country and oh gosh, and say things like, man, we are really messed up, and gosh, sometimes the way things go down here in the United States, I don't know. Anytime you are having that feeling, consider looking at laws in some other countries, and be grateful that even though we do have clearly some issues in the United States, a lot of other countries have it a lot worse. So, sources of laws. Here's some other, just kind of a little chart that shows you what we just talked about. Okay. That was criminal law that we were talking about. Civil law is different in that, let me see how I can describe this. Civil law is basically when you are suing someone because they have failed to do something, or basically because they have failed to do something. The big difference between civil law and criminal law is that if you are being sued in a civil court, you are typically at risk of losing money or something of monetary value. If you are being charged in a criminal court, you are at risk of losing your freedom. So those are the two really significant differences. That's the big significant difference. So you have a lot more rights as a defendant in criminal court because losing your freedom is seen as a lot more significant than losing your money. And some of you would argue that losing your money is just as important, maybe even more important. I don't know. Civil law is a system of laws used by many countries that do not use the common law system. And this is non-criminal law. Basically deals with disputes between individual parties, or like if I was walking into Target and I slipped and fell, could I sue Target for money? Yeah, so it's things like that could also be a civil lawsuit. I'm thinking right now, Alec Baldwin just shot and killed somebody on a movie set. Will he be criminally responsible for that? I don't know, pretty doubtful. But will he be civilly? Will they sue him civilly? I don't know. And I'll tell you another thing about that. Let me see. Sorry, I had to go look and make sure. The burden of proof for both types of court proceedings is different. In civil law, the burden of proof is a preponderance of the evidence, whereas in criminal law, the burden of proof is beyond a reasonable doubt. So the burden of proof is much higher in a criminal case because what the defendant has to lose is much more significant than in a civil case. Okay. The person who is initiating the lawsuit or suing someone in civil court is called a plaintiff. The person who's being sued is the defendant. That whole lawsuit is basically called a tort, and damages is the money that's ordered to be paid. Let me go back here one more time. I want to talk about one case that is really easily explains these two things. So I want to make kind of a story about the O.J. Simpson case. We're going to talk about O.J. Simpson. O.J. Simpson let's say that O.J. Simpson. You know what? Let's just talk about his case in general. Actually, the real case. So O.J. Simpson went to court. He was charged with the murder of his wife, Nicole Brown Simpson. And he was acquitted or found not guilty of her murder in a criminal court. Shortly after that trial, he was tried in civil court for wrongful death in the death of Nicole Brown Simpson. He was found civilly responsible for wrongful death and was ordered to pay millions of dollars. It's the same case. It's two different types of courtrooms where the burden of proof was different. In his criminal case, the burden of proof was beyond a reasonable doubt. The jury simply couldn't find beyond a reasonable doubt that he was guilty. However, in the civil case, the jury's burden of proof was only a preponderance of the evidence. It's a lower burden of proof. He more likely did it than did not. So they found, he was responsible. We think he probably was responsible. So he was ordered to pay millions of dollars to Nicole Brown Simpson's family. Interesting. Okay, criminal law. You all are probably familiar with what criminal law is, but this is the body of law that basically says, if you do this, you could go to jail or prison. Double jeopardy means that you cannot be tried for the same crime twice. Tried is the main word here. A lot of you are going to write on a quiz that I give you, you can't be charged with the same crime twice. That is not true. You can't be tried for the same crime twice. Sometimes the DA or the prosecutor will dismiss a case and then refile it. That's okay. As long as the person has not been acquitted of that crime or gone to trial already for that crime, the DA can do that. If a person has been acquitted of that crime or found not guilty, the DA cannot prosecute that case again. Let me give you another example. Again, Mr. O.J. Simpson. His case is perfect for this class, by the way. Anyways, O.J. Simpson, he was tried for the murder of Nicole Brown Simpson. I know, I already said that, right? Okay, so he was acquitted. After that, he was ordered to pay millions of dollars to Nicole Brown Simpson's family. And let's say he was broke and he wanted to earn some money. So he decided that, and this is fake, I'm making this part of the story up. Let's say he decided he wanted to do an interview for $10 million, and he decided to go on Oprah and confess. Oprah, I killed the bitch, she deserved it, and he went on live TV and he told the whole world what he did, exactly what he did, step by step, and how he killed Nicole Brown Simpson. Could they charge him with that crime after he was acquitted, even though he went on TV and said the whole story and admitted it? Absolutely not. It would be double jeopardy because he's already been tried and acquitted. Okay, restitution is the next little bullet point here. Restitution is money to be paid back to the victim to make the victim whole. So like if the victim's, car was wrecked during a high-speed chase, if the victim's diamond ring was stolen, something like that, the suspect would have to pay it back. So this is a slide that talks about the difference between criminal and civil. Felonies and misdemeanors. Do not get caught up on violence as a difference between felonies and misdemeanors. Felonies, think receiving stolen property of, let's say, a wad of cash, $10,000. Someone gave me $10,000 in stolen money, and I knew it was stolen. That is a felony. Is that violent? No. So does it have to be violent to be a felony? No. Don't get caught up on that. It also does not have to be a federal offense to be a felony. Okay, so having said that, those are things that students get confused on a lot, so I wanted to kind of throw it out there first. Felonies are typically a little more serious offense. They're more serious. You can go to jail or prison for more than a year. They are typically, restitution fines are much higher for felonies, but they are typically more serious offenses for which a person can actually go to prison or jail for more than a year. A capital felony is an offense for which a person could receive the death penalty. Misdemeanors are criminal offenses for which a person could go to jail for up to a year. Now, again, can a misdemeanor be a violent offense? Yeah, if I slap someone across the face, that's a violent offense. As long as I haven't broken any bones or done anything, caused any significant harm, that's probably a misdemeanor though. So keep in mind, violence isn't necessarily the key. Infractions, that's going to be probably something like your traffic ticket, things like that. Things for which you cannot go to jail, typically. Wobbler, I know it sounds like a really stupid word. Why do we still call them wobblers? I don't know. But a wobbler is an offense that can be charged as either a felony or a misdemeanor. And there are a few offenses or charges that are like that, like vehicle theft is one of them. In California Vehicle Code Section 10851 sub A can be charged as a felony or a misdemeanor, and typically it depends on the severity of the offense. If it was it kind of just depends on the severity of the offense. A lot of times DAs will use charge them as felonies and use the misdemeanor hook to get people to plead out. But there are a decent number of charges that can be charged as misdemeanors or felonies, and they are called wobblers. wobblers. And we already talked about infractions, typically something like a traffic violation or something on the smaller end. Corpus delicti means the body of the crime. I just zoned out there. Body of the crime, or the elements of the crime. There are certain things that need to happen in every crime. Things like battery. Misdemeanor battery is like, a lot of you would probably consider it like assault, but battery. That is an unlawful touching with intent. So there's certain things that have to happen. In order for me to commit a battery, I can't just trip and fall forward and accidentally hit somebody. I have to have intent. All of the elements of the crime have to be there in order for a prosecutor to be able to prove beyond a reasonable doubt that I committed the crime, that the elements of the crime have been proven beyond a reasonable doubt. So a lot of offenses, not all of them, but a lot of offenses require intent. So that's kind of the tricky part a lot of times for a prosecutor or a DA, as I call them, district attorney, to show that a person had intent. Again, if I'm walking down the hallway at school, I trip and I fall, and again, I fall forward and my arm falls forward and I punch a student in the face. Can I be charged with battery? Yeah, probably not, unless someone is somehow able to prove that I meant to do that and I meant to punch that student in the face. So the elements of the crime, corpus delicti, must be proven. Actus rea and mens rea. When I tripped, fell forward, and punched the student, I committed the guilty act, or the actus rea. I actually did hit the student in the face. But I didn't have the guilty mind, the mens rea. I just tripped. It was an accident. I did not mean to do it. Granted, that's a silly example, but hopefully you get what I'm saying here. The guilty act is the actus rea, a specific act that has to take place in order for a person to be charged with a crime. But the guilty mind, level of intent, has to be there for most crimes, not all. So again, don't get me wrong. This does not have to be there for all crimes. Not all crimes require intent. Think DUI. You do not have to require to kill somebody in a DUI in order to be charged with that crime. So there are some crimes for which you do not have to have intent. All you have to do is commit the act. Strict liability. Okay, purposefully, knowingly, recklessly, and negligently. These are all different levels of mens rea. If someone did something on purpose, they intended to do it. They knowingly, they actually were aware that they were doing it. They were reckless or they were negligent. They should have known better. They did something risky. So here is another little chart with the elements of the crime. Oh, God, I hate this one. I remember I'd never heard of this until I taught this class. I even had to look up how to pronounce it. Inchoate crimes. These are crimes that have not actually been complete. This is like the undercover crimes where someone tries to hire someone to kill their husband or their wife or something like that. They try and hire a hitman, but they really hired a cop. So these are those types of crimes. So a person who gets arrested for trying to have their spouse or their whoever murdered, but they didn't. It's an attempt, conspiracy, or solicitation. Those are, even though the crime did not actually take place, they are still going to be held responsible for those. causation, concurrent. I'm going to kind of skip that one. Okay. Good God, this is long. Holy shit. We're still going. Oh my God. I'm going to break this one down. Let's stop, and then I'm going to break it down to part 2.